Now, this is a little bit tricky from a legal perspective, also practically, and it's tricky because the AI Act obligations are separate from the copyright directive obligations. So in a way, by giving too much weight to these, you're helping determine to what extent you've complied with the obligations in the copyright directive, which leads to different consequences, right? If you infringe the AI Act, it's basically a public law instrument that has its own sanctions and remedies, but mostly no private right of action and infringement of copyright are derived from there. But they might help determine whether or not you breached the conditions or didn't meet the requirements of the TDM exception, and in doing so, be decisive in determining whether or not you're infringing copyright at the level of the TDM. So it makes the interaction extremely complex, and it makes how you draw these requirements important. Now, whether or not in practice this will help, it really depends on the level of the detail of the summary. If it's too vague, it's meaningless. If you don't have to disclose too much, it's also pretty irrelevant. But if it is well drawn up, it might be quite useful, I would say, especially for the level of these players here. Now, of course, and I would end with this, again, this is an obligation imposed on the GPAI model provider. So if the provider obtains the data sets, for example, from parties that are upstream, as I mentioned before, the example that everyone discusses is Leon, but then Common Crawl and the like, then the question that is before us is, okay, the provider itself didn't do the scraping, it's just obtaining the data set. So how do you deal with this relationship between the GPA model provider and its upstream providers that are not subject to the AI Act?